Hello all, welcome to Lucid Minds Current Affairs program brought to you by New IAS, and today we will be discussing about the recent issues that have had transpired within the CBI, and this is a very important topic for interview as well as 2019 UPSC mains examination. This is a short timeline of the things that have happened so far. First is the conflict between the CBI Director and the Special Director. The then CBI Director Alok Verma and Special Director were quarreling between each other, and this led to the government removing both. And both of them approached the Supreme Court. And however, the Supreme Court then went on to reinstate Alok Verma, but the case related to Special Director, the former Special Director Rakesh Asthana, is still pending. But we have already covered this topic in a previous video, so please do check it to be up to date with the issue. Now, like I said right now, the Supreme Court went on to reinstate Alok Verma to the post of CBI Director, and the Supreme Court, however, withheld his powers and referred to the selection committee to deal with the issue of CBI Director's power. However, the selection committee, which met after the Supreme Court order reinstating Alok Verma, had transferred the CBI Director to another post, and in effect, CBI Director Alok Verma became the first to be sacked from the post of CBI Director. Now, after that, Andhra Pradesh and West Bengal denied permission to CBI to investigate cases, and it was after this that the selection committee headed by the Prime Minister appointed the new director Rajiv Kumar Shukla. This was done immediately after the transfer of Alok Verma to another post, and after this the West Bengal police detained the CBI officers who were investigating the Sharda chit fund scam. Now, a little bit of the history behind the CBI. The Special Police Establishment was set up in 1941 to probe bribery and corruption in the country during the World War II. That agency was part of India's War Department, and it was India's first agency to investigate corruption. In 1946, it was brought under the Home Department, and its powers was expanded to investigate corruption in central and state governments under the Delhi Special Police Establishment Act. That law gave the central government, that is the Delhi Special Police Establishment Act, gave the central government the right to set up and govern a special police force to investigate acts of corruption. Now, this Delhi Special Police Establishment Act gave the central government the right to set up and govern a special police force to investigate acts of corruption. Now, the Special Police Force became the Central Bureau of Investigation after the Home Ministry, which is in charge of domestic security, decided to expand its powers and change its name in 1963. Now, the CBI is still governed under the Delhi Special Police Establishment Act passed in 1946, but in a series of moves in the 1960s, its powers were expanded from investigation of corruption among senior federal civil servants to being able to probe irregularities at all public sector bodies, including state-owned banks. Its investigation also includes prominent crimes like the case of murder and kidnapping, and these are cases that are referred to the CBI by the states concerned. Next is the appointment of the CBI Director. Now, the amended Delhi Special Police Establishment Act empowers a committee to appoint the Director of CBI. The committee consists of the Prime Minister, who is the chairperson of the committee. The leader of opposition of Lok Sabha is a member of the committee, and Chief Justice of India or a Supreme Court judge recommended by the Chief Justice is the third member in this committee. Now, when making recommendations, this selection committee considers the views of the outgoing director. This selection committee was actually constituted under the Lokpal and Lokayukta Act of 2013. What is the legal position of CBI? The legal powers of investigation of the CBI, its duties, privileges, and all are derived from the Delhi Special Police Establishment Act of 1946. Also, the central government may extend to any area the powers and jurisdiction of the CBI for investigation, but this is subject to the consent of the government of the state concerned. However, the central government may not extend the CBI's jurisdiction to a union territory. Now, the first important topic under CBI that we shall discuss about is the appointment of the new CBI director. In our previous video regarding the CBI issue, we had discussed in depth about the conflict between CBI Director Alok Verma and the Special Director Rakesh Asthana. So, we will not be covering that issue in detail here. But after the central government removed both of them, the CBI chief Alok Verma went to the Supreme Court stating that his removal was illegal. So, the Supreme Court reinstated CBI chief Alok Verma 3 months after the government divested him of his power, and the Supreme Court permitted Alok Verma back into his office but withheld his power to make any major policy decisions. The Supreme Court asked a high power committee under the Prime Minister, the leader of opposition and Chief Justice of India to meet and decide on the powers or the status of the CBI director within a week. Until the high powered committee decides what to do with him, the Supreme Court withheld the powers of CBI director Alok Verma. But what happened after that was that the CBI director Alok Verma was removed from his post after the high court committee headed by Prime Minister Narendra Modi decided to remove him from the post, making him the first CBI chief in its history to face such an action. Now, the high powered committee consisted of the Prime Minister, the leader of opposition Mallikarjun Kharge, and Justice Sikri, who was nominated by the Chief Justice of India Ranjan Gogoi. Since then, the CBI chief's post had been lying vacant, and after the unceremonious exit of Alok Verma, who had been engaged in the bitter fight with the Special Director Rakesh Asthana. So, the CBI chief's post has been lying vacant since January 10 after the exit of Alok Verma, and later on the committee headed by PM appointed IPS officer Rishi Kumar Shikla as the new director of the Central Bureau of Investigation. The leader of opposition Mallikarjun Kharge had voiced his dissent to this decision, but Rishi Kumar Shukla's name was backed by both PM Modi and Justice Sikri, and the appointment came almost a day after his name was shortlisted during the second meeting of the selection committee headed by the Prime Minister. Now, next is the CBI and its dispute with the states, which is the most pressing issue that the CBI is facing right now. States of Andhra Pradesh and West Bengal withdrew general consent to the CBI for investigating cases in their respective states, and the state government said that they had lost faith in the CBI in the backdrop of the CBI's internal turmoil marked by the open war among the agency's top officers. They also alleged that the centre is using the CBI to unfairly target opposition parties. In West Bengal, the current case is related to the Sharda chit fund scam, which was handed over to the CBI by the Supreme Court itself. The CBI officers were not permitted to investigate the West Bengal officials related to the Sharda chit fund scam, and the CBI officials were arrested, and that too it was done on a day before the new director R.K. Shukla was to take charge as the director of CBI. Now, Section 5 of the Delhi Police Special Establishment Act extends the power and jurisdiction of special police establishment to other areas. Section 6 says that the section 5 shall not be deemed to enable any member of the Delhi Special Police establishment to exercise their powers and jurisdictions in any area in a state without the consent of the government of the state concerned. That is, section 6 is what enables the general consent of the state governments to the CBI. So without this consent, CBI cannot investigate cases within the states. Now what it means is that all states except Delhi and Union Territories have the discretion to give their consent to the CBI for a probe in the states. The Delhi High Court on October 2018 ruled that the CBI need not seek the state's consent for investigation under the DSP Act except when the case is registered in such state. That is, the CBI can investigate cases as long as the case is filed outside the state concerned. The order was given with regard to a case of corruption in Chhattisgarh, which also gives consent on a case-to-case basis. The court ordered that the CBI could probe the case without prior consent of the Chhattisgarh government, since the case was registered in Delhi and not in Chhattisgarh. So what is general consent? Unlike the National Investigation Agency, which is governed by its own NIA Act and also has jurisdiction across the country, the CBI is governed by the Delhi Special Police Establishment Act that makes consent of a state government mandatory for conducting investigation in that state. Now there are two kinds of consent, case specific and general. Now case specific is related to various cases in which the state or the high court in a state grants CBI to investigate various cases, and given that the CBI has jurisdiction only over central government departments and employees, it can investigate a case involving state government employees or a violent crime in a given state only after the state government gives its consent to investigate. Now general consent is normally given to help the CBI seamlessly conduct its investigation into cases of corruption against central government employees in the concerned state. Almost all states have given such consent, otherwise the CBI would require consent in every case. For example, if it want to investigate a bribery charge against a Western Railway clerk in Mumbai, it would have to apply for consent with the Maharashtra government before registering a case against him. But since the general consent is normally given to CBI, it need not seek this consent to investigate the said clerk. Now what was the position till now? Now there was a blanket permission from all states to the CBI for corruption probes. In many cases, the CBI could write to the states for a countrywide probe, and as an example, back in 2013, many states had withheld consent from a probe in the coal block allegation scam, which was called as the Coal Gate, for several months. So what does this withdrawal of general consent mean? It means that the CBI will not be able to register any fresh case involving a central government official or a private person stationed in these two states of Andhra and West Bengal without getting case specific consent. This will also be applicable to big ticket corruption cases within the state, and this means raids in fresh cases will require sanction from the state concerned or else from a high court or the Supreme Court. So does that mean the CBI can no longer probe any case in these two states? No, the CBI would still have the power to investigate old cases registered when general consent existed. Also, cases registered outside these states but involving people stationed in these states would allow CBI's jurisdiction to extend to these states. This was the crux of the October 2018 Delhi High Court order, and there is also an ambiguity on whether the agency can carry out a search in either of the two states in connection with an old case without the consent of the state government. However, there are legal remedies to that as well. The CBI can always get a search warrant from a local court in the state and conduct searches in these states. So, what happens in fresh cases? Now, the withdrawal of consent will only bar the CBI from registering a case within the jurisdiction of Andhra and Bengal. The CBI could still file a case in Delhi and continue to probe people inside these two states. Now, the October 2018 order of Delhi High Court makes it clear that the CBI can probe anyone in a state that has withdrawn general consent if the case is not registered in the state. Now, the order was given with regard to a case of corruption in Chhattisgarh, which also gives a consent on case-to-case basis. The court ordered that the CBI could probe the case without prior consent of the Chhattisgarh government, since the case was registered in Delhi. Thus, if a state government believes that the ruling party's ministers or members could be targeted by the CBI on orders of the centre and that the withdrawal of general consent would protect them, it would be a wrong assumption. CBI could still register cases in Delhi, which would require it would only require that some part of the offence being connected with Delhi and still arrest and prosecute ministers or MPs. But is this the first time that this has happened? Is this the first time that states are withdrawing consent to the CBI? Not really. Over the years, several states have done so, including Sikkim, Nagaland, Chhattisgarh and Karnataka. And Karnataka stands out as an example here. In 1998, the Janata Dal government had withdrawn general consent, and in 1999, the Congress-led government took over but did not revoke the previous order revoking the general consent, and the general consent wasn't renewed for 8 long years. The CBI had to virtually close down its office in Karnataka. The agency had to seek permission of the state government for every case and every search it conducted on central government employees. Now, what are the legal backgrounds regarding such investigations? First is that law and order are a state subject under the Constitution of India. The CBI draws its powers from the Delhi Special Police Establishment Act, and even for handing over cases to the CBI, the High Courts and Supreme Courts listen to the response from the states concerned. However, this development may not apply on existing cases and on cases where a High Court or the Supreme Court of India hands the probe to the CBI. So, basically in the Sharda chit fund scam, the general consent may not apply as the case was given to the CBI by the Supreme Court of India. This development does not apply on central government matters within a state, such as a corruption case against a senior central government bureaucrat who is posted in the state of Andhra or West Bengal, or a bureaucrat in a central PSU, and cases can still be filed under the Prevention of Corruption Act. So, what are the shortcomings of CBI? For institutions like CBI and many others, the government of the day can appoint its choice of director entirely as it wished, without any of the checks and balances that are common for key posts in modern democracies. Now the CBI is run by IPS officers on deputation. Now, this is susceptible to the government's ability to manipulate the senior officers because they are dependent on the central government for future postings and transfers. Now, the agency is dependent on Home Ministry for staffing, Law Ministry for lawyers, and it also lacks functional autonomy. Equally worrisome is that the CBI evolved in bits and pieces from the hastily enacted 1946 Delhi Special Police Establishment Act, and to this day it is governed under the same act, that is the Delhi Special Police Establishment Act. Now, CBI's legislative frameworks are woefully inadequate for the premier national investigating agency for crime and corruption, and another shortcoming is that CBI needing state government's authority to investigate cases in a state, even when such investigation targets a central government employee. Now, since police is a state subject under the constitution and the CBI acts as per the procedure prescribed by the CRPC, that is the Code of Criminal Procedure, which makes it a police agency. The CBI needs the consent of the state government in question before it can make its presence in that state, and this is a very hard, very difficult procedure. Now, the CBI's investigation of Bofors case during Rajiv Gandhi's tenure raised a number of issues in public debate which have remained unanswered to this day. After the passage of Right of Information Act in 2005, it was hoped that the agencies like CBI would be open to public scrutiny to some extent. But the CBI has conveniently managed to get itself exempted from the purview of the RTI Act, and this exemption was even upheld by the Madras High Court. Also, importantly, the CBI is not financially independent, making it prone to government intervention. Now, the CBI Director is not allowed to report directly to the Minister of Personnel. He has to go through the DOPT even for administrative matters. Sometime back, after the removal of Alok Verma as the CBI Director, we had a temporary chief in Nageshwara Rao. A temporary chief does not enjoy statutory protection to insulate the office from government interference, and after the appointment of Nageshwara Rao, there were so many transfers that had happened within the CBI, and one such transfer was that of the investigating officers of the Muzaffarpur shelter rape case, and because of this transfer, the interim director had drawn the ire of the Supreme Court and is facing contempt charges. Now, it is also symptomatic of a larger problem that the CBI faces. Governments are reluctant to reform the CBI as the agency has been used as a tool for political intimidation. Now, the CBI was claimed to be a case parrot back in 2012 by the Supreme Court. Consequently, well-meaning suggestions of reforms such as new comprehensive legislations are pushed under the carpet by the political executive. Institutions without a proper head add to the prevailing chaos and further erode public trust in governance. Now, there have been various recommendations for reforming the CBI, and most of the recommendations revolved around CBI getting a statutory status. In 1978, the LP Singh Committee recommended the enactment of a comprehensive central legislation to remove the drawback of not having a central investigative agency with a sufficient statutory charter of duties and functions. This was followed by the recommendations of the Estimate Committee of the Parliament in 1991. The committee had urged that a clear-cut policy should be laid down, stating the purpose of CBI's functioning, and had suggested a legislation defining its charter. The committee was firmly of the view that unless the CBI was given statutory status and a well-defined legal power to investigate cases which have ramifications in states, its effectiveness would decline substantially and steeply. A Supreme Court judgment in the 1997 Vinith Narayan vs. The Union of India resulted in the formation of Appointment Committee for the CBI and the Central Vigilance Commission, constituted of members from government, opposition and judiciary. Now, the SC also stipulated a fixed 2-year tenure for the CBI chief and also mandated a supervisory role over the CBI for the CVC, the Central Vigilance Commission. Now, a parliamentary standing committee report in 2007 recommended for a separate act for CBI in tune with the requirements of the time, and this was followed by a 2008 parliamentary standing committee report which was of the opinion that the need of the hour was to strengthen the CBI in terms of legal mandate, infrastructure and resources. What are the various CBI reforms that we should focus on? The first reform is to ensure that the CBI operates under a formal, modern legal framework that has been written for a contemporary national investigative agency. A new CBI Act should be promulgated that ensures the autonomy of CBI while at the same time improving the quality of supervision. Now, one of the demands that has been before the Supreme Court is for the CBI to develop its own dedicated cadre of officers who are not bothered about deputations or abrupt transfers. It is also possible to consider granting the CBI and other federal investigating agencies the kind of autonomy that the Comptroller and Auditor General enjoys. The CAG is accountable only to the Parliament and not to the central government. It is high time that the CBI is mandatorily kept at an arm's length from the government while investigating politically sensitive cases. Now lastly, the way forward. The CBI needs freedom from the colonial era law and also from opaque government vetoes. Both the union government's prior approval and states' consent for initiating certain investigations also need to go. In its place, the CBI requires clear guidelines, checklists, and stipulated internal time-bound procedures and practices. Now, the CBI continues to operate under a notification issued by the Ministry of Home Affairs for investigating crimes under the Delhi Special Police Establishment Act and a comprehensive Act of Parliament setting out the autonomy, powers, etc. is the first step towards improving the CBI's autonomy. CBI should also have its own cadre of officers and be less dependent on other ministry for personnel. It is unfair to blame the organization when it is not given the requisite legislative framework nor the manpower and financial resources to govern itself. It is also essential that it does not become a political tool and is given with its own jurisdiction and legal powers. Thank you.